Imagine a world where artificial intelligence is not just assisting human creativity, but actively shaping it. Writing books, composing music, generating artwork, and even crafting legal arguments. This is no longer a futuristic fantasy, it's happening right now. But with this groundbreaking advancement comes an urgent legal and ethical question. Where do we draw the line between innovation and infringement? In an age where AI can replicate human creativity with astonishing accuracy, how do we determine what falls under fair use and what constitutes copyright violation? Today, we're diving into one of the most pivotal legal battles shaping this discussion: Thompson Reuters versus Ross Intelligence. This case isn't just about two companies fighting in court. It's about defining the future of AI and content creation. If you're a creator, a tech enthusiast, or simply someone curious about how artificial intelligence is challenging traditional copyright laws, this discussion is for you. By the end of this video, you'll have a deeper understanding of fair use, the legal arguments in this case, and what it means for the future of AI-generated content. AI is changing the creative landscape at an unprecedented pace. It is no longer just a tool for automating mundane tasks. It has become a powerful force in generating original works. From music and art to legal research and journalism, AI tools can write entire articles, create stunning visuals, edit videos, and even compose film scores, all with minimal human input. This has made content creation faster, more efficient, and more accessible to people who may not have traditional training in these fields. However, with great power comes great legal complexity. The fundamental issue arises from the fact that AI models are trained on vast amounts of existing data, much of which is copyrighted material. This raises critical questions about ownership, originality, and authorship. If an AI generates a piece of content, who owns it? Is it the developer who programmed the AI, the entity that provided the training data, or the AI itself? More importantly, does AI's reliance on copyrighted material for training constitute fair use, or is it a form of large-scale infringement? Copyright laws were designed to regulate human creativity, but AI-generated works do not fit neatly into existing legal frameworks. This legal ambiguity is creating challenges for both AI developers and traditional content creators who worry that AI-generated works could devalue or directly compete with their own. This uncertainty has serious implications. If fair use becomes more restrictive, creators and AI companies may find themselves in legal gray areas, unsure of what content they can legally use. This could lead to self-censorship, stifling innovation, and discouraging experimentation with AI-assisted creativity. On the other hand, if fair use protections expand to accommodate AI, it could provide creators with more freedom while raising concerns about the potential for widespread copyright infringement. The legal uncertainty surrounding AI-generated content has already increased the need for legal counsel, forcing creators and companies to navigate a rapidly evolving regulatory landscape. To fully understand the stakes in this case, we need to break down the concept of fair use. Fair use is a legal doctrine that allows limited use of copyrighted material without permission under specific conditions. It is designed to balance the rights of copyright holders with the need for public access to information and creative expression. The law evaluates fair use based on four key factors: the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used, and the effect on the potential market for the original work. The first factor, purpose and character, examines whether the use is transformative, meaning that it adds new meaning, context, or value rather than simply copying the original work. The second factor, nature of the copyrighted work, considers whether the original content is factual or creative, with factual works being more likely to qualify for fair use. The third factor, amount and substantiality, looks at how much of the original work is used and whether the portion taken is the heart of the work. The final factor, market effect, considers whether the use of the content competes with or diminishes the value of the original. Traditionally, fair use is applied to fields like journalism, education, and commentary, but AI is challenging these boundaries in ways the law was never designed to address. If AI-generated content is considered transformative, does that justify its reliance on copyrighted training data? If an AI-created article or legal brief replaces the need for human-written content, does it unfairly impact the original creator's market? These are the questions at the heart of the Thompson Reuters vs. Ross Intelligence case. This legal battle revolves around whether AI's use of copyrighted material qualifies as fair use or infringement. Ross Intelligence developed an AI-powered legal research tool that used Thomson Reuters' proprietary legal database to train its system. Thomson Reuters, which owns the well-known Westlaw legal research platform, sued Ross Intelligence, arguing that its AI unlawfully copied and repurposed their copyrighted legal texts. Ross Intelligence countered that its AI was not simply copying, but transforming the material for a different purpose, making it fair use. This case is significant because it directly challenges how fair use applies to AI-generated content. If the court sides with Thomson Reuters, it could set a precedent that AI companies must obtain explicit permission before using copyrighted materials for training. This could lead to stricter copyright enforcement, making it harder for AI developers to build sophisticated models. Conversely, if Ross Intelligence wins, it could expand the scope of fair use, allowing AI to freely use copyrighted content as long as the output is deemed transformative. AI's ability to mimic human styles and techniques adds another layer of complexity to the ongoing debate over fair use and copyright law. As artificial intelligence grows more advanced, it can now generate paintings, music, literature, and even film scripts that closely resemble the works of well-known creators. This raises a critical legal and ethical question. If an AI-generated artwork mimics the distinctive brushstrokes of a famous painter or the unique sound of a legendary musician, is it simply a form of inspiration, or does it constitute copyright infringement? How do we differentiate between homage, imitation, and outright theft in a digital age where AI can replicate human creativity with remarkable precision? This issue extends far beyond the arts. AI is increasingly used to generate news articles, legal arguments, and academic research papers, areas that rely heavily on originality and credibility. If an AI-generated article adopts the style, tone, or research methods of a renowned journalist or scholar, should it be treated as an original work, or does it infringe upon the intellectual property of the original author? Similarly, if an AI composes a song in the unmistakable style of a famous musician, does that musician have grounds for legal action, even if the AI-generated piece contains no direct sampling of their work? These questions strike at the very heart of what it means to create something original. Historically, originality has been a cornerstone of copyright protection, with laws designed to protect human creativity from unauthorized reproduction. But AI complicates this framework by blurring the lines between originality and replication. If an AI system is trained on thousands of copyrighted works and then produces something new, is it genuinely original, or is it merely an amalgamation of pre-existing material? And if an AI-generated work is so convincingly human-like that it becomes indistinguishable from something crafted by a human artist, writer, or composer, should it receive the same copyright protections? Another key issue is whether AI should be viewed as a creative tool or as an independent creator. If AI is merely a tool like a paintbrush, camera, or typewriter, then the human operator, the person guiding the AI, could be considered the true creator and copyright holder. However, if AI is seen as an independent entity capable of generating original works without direct human input, then new legal frameworks may be needed to determine ownership and rights. Who, then, owns an AI-generated work? The programmer who built the AI? The company that owns the AI system? Or does AI-generated content belong to the public domain, freely accessible to all? For creators, this case underscores the importance of understanding the legal landscape surrounding AI. When using AI-generated content, it is crucial to consider where the training data comes from, how transformative the content is, and whether it competes with existing copyrighted works. Transparency, attribution, and staying informed about evolving copyright laws are essential to avoiding legal complications. The outcome of this case will likely shape future policies regarding AI and fair use. If courts establish stricter guidelines, AI companies may need to license copyrighted materials, leading to more regulated but potentially more expensive AI models. If fair use is expanded, AI innovation could accelerate, but concerns about protecting human creators will persist. This legal battle is just the beginning. As AI continues to evolve, copyright laws must adapt to balance technological process with the rights of original creators. The future of fair use is still unwritten, and the decisions made today will impact the creative world for years to come. What do you think? Should AI be allowed to use copyrighted material for training, or do we need stricter protections for creators? Thanks for watching. Please like the video, press the subscribe button, and also drop your thoughts in the comment section.